It already is changing the way businesses operate, how people work, and how we solve problems throughout our society. From agriculture to manufacturing to customer service, AI is showing up in more places every day, and it's helping Americans get more done faster and more efficiently. There's no doubt this is a big moment for both America and the rest of the world. But the question before us today is this: will we respond to it with more freedom or with more government control? America has always led the way in innovation, not because we have the biggest government, but because we have trusted our people. We believe in free markets, competition, and limited government. That's what built our economy, and that's how we create new technologies, from the light bulb to the smartphone. And that's why the United States, not China or Europe, has been the global leader in innovation for over a century. And that same model is working in AI. The story we hear sometimes is that a few big companies are dominating the AI sector. But when you look closer, the story unravels. Throughout this industry, there is real competition happening at every layer of the AI sector, in cloud infrastructure, in AI models, and in tools and applications. It's true that big tech plays a role in this sector, but you also have startups, open source developers, university labs, and solo engineers pushing the boundaries of this exciting new technology. Small businesses are using AI to do things they never could afford before: automate routine tasks, improve customer service, analyze data, write content, design products, and more. AI is helping the little guy compete with the big guys. It's lowering barriers to entry across the board. This isn't a monopoly story, it's a success story. It's the free market doing what it does best. But unfortunately, some in government want to step in and start regulating before they even understand what they are regulating. They want to create sweeping new rules or even whole new agencies to oversee AI under the claim of safety and of fairness. They want to decide which models are quote-unquote responsible, which tools are quote-unquote approved, and which approaches are fair, and who gets to build what. That's very dangerous. We see this same saga playing out time and time again. Overregulation can kill innovation. When government inserts itself too early, it locks in incumbents, drives up costs, and freezes the market. Startups get squeezed. The rules benefit the insiders, and innovation slows to a crawl. Meanwhile, our competitors, especially in China, aren't waiting around. They're pouring billions into AI development. They're using it to monopolize their military, monitor their citizens, and try to leapfrog the U.S. on the global stage to the detriment of Democrat principles and values. And over in Europe, the EU is rolling out a top-down AI regulatory regime that already is causing problems for American companies trying to do business overseas. The rules are vague, burdensome, and constantly shifting. And they've been written by bureaucrats who aren't accountable, certainly, to the American people. We should not copy China's model of control, and we should not copy Europe's model of overregulation. We need to stay true to what works, and that is free enterprise, open competition, and light-touch regulatory approach that allows innovation to flourish. That doesn't mean we ignore real problems. We should enforce our existing antitrust laws if companies are abusing their market power. We should be on guard against fraud, abuse, and national security threats. But we don't need a heavy-handed new regulatory regime to do that. What we need is to keep the U.S. the best place in the world to build, test, and deploy AI. That means making room for new entrants. It means protecting free speech in the digital age. And it means making sure American entrepreneurs, not unelected regulators, are the ones shaping the future of this technology. AI is a tool. Whether it helps or harms depends on how we use it and whether we keep the freedom to innovate, adapt, and compete. The worst thing we can do is let fear drive us into giving up control to Washington, to Brussels, or to Beijing. The American model has always been the best model. Let's stick to it. I want to thank the witnesses for appearing before us today, and I look forward to hearing what each of you has to say. I now recognize the ranking member, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman, and thank you to our witnesses, particularly to Commissioner Bedoya for joining us today. As we examine innovation and competition with respect to artificial intelligence, we must keep in mind three simple truths. First, there is no artificial intelligence exception to the antitrust and consumer protection laws. Second, there is no DOGE exception to federal privacy protections. And finally, there is no presidential exception to following federal laws. It is a sad comment on the time we find ourselves in that these undeniable and basic propositions must be continually affirmed. AI technology is rapidly advancing and promises to transform our society in ways we cannot even imagine today. But while AI will deliver many economic and social benefits, it also poses tremendous risks that we are just beginning to grapple with. And with control of AI technology in the hands of just a few entrenched companies, it is important that we keep a watchful eye on the industry with thoughtful regulation that will foster growth and innovation while protecting consumers. One of the most critical tools in this effort is antitrust and consumer protection enforcement, led by the Federal Trade Commission, an independent administrative agency that was created more than 110 years ago by Congress as the nation was beset by powerful monopolies that dominated core industries in society. Its specific mission is to protecting the public from deceptive or unfair business practices and from unfair methods of competition. Its structure is deliberately bipartisan, with no more than 3 members of the 5-person commission able to be from a single party. This makeup, along with the fact that the commissioners are meant to serve staggered 7-year terms and are removable only for very specific causes, is designed to increase the independence and thereby the prestige of the commission. We need the FTC now more than ever as we confront an AI-induced wave of competition, consumer protection, and privacy-related issues. And yet, the Trump administration is undermining the single agency best positioned to address them. Years before ChatGPT burst onto the scene, the FTC was already working to protect consumers by stopping the largest semiconductor chip merger in history. Chips are an essential input to AI, and blocking this merger helped protect innovation by preserving competition for this vital tool. Using their unique power as part of the Commission's study function, the FTC also produced a report examining AI investments and partnerships that would best enable the agency to ensure that when dominant companies pursued these practices, they did not undermine competition and innovation. With more and more companies relying on AI to make fundamental decisions that affect consumers, the FTC has also carefully examined the algorithms that power these systems. In particular, the commissioners tackled algorithmic bias and algorithmic collusion, which is when a computer system systematically produces unfair outcomes or is used to engage in anti-competitive pricing, respectively. This work is essential to ensure that as AI develops, it serves the American people. If we are serious about promoting competition and innovation in AI, we need a strong FTC to enforce the law. But instead, the Trump administration has done all it can to hobble the agency and to weaken enforcement of antitrust and consumer protection laws. Even more troubling, while with one hand the administration is undermining regulation of AI, with the other hand it is handing massive troves of sensitive data on millions of Americans to Elon Musk and his DOGE team that could be used to deploy AI throughout the government. Governmental processes, its workflows, and the use and interpretation of government data are highly complex. There is scant evidence, however, that AI can be successfully deployed in government on such a far-reaching scale. But Musk and DOGE seem intent on forcing the American people to embark on a grand experiment based on little more than their faith in AI technology, an experiment that places all of our privacy and security at great risk. And while all this unfolds, Commissioner Bedoya should be participating in any number of matters protecting consumers. Even as a minority commissioner, he and his fellow Democratic Commissioner Rebecca Slaughter occupy an important and congressionally mandated role. They are fundamental to infusing commission deliberations and decisions with a bipartisan dimension. Oftentimes, minority commissioners influence the outcome or logic of the decision. But even when they do not, they perform the essential function of providing transparency into the process, including by highlighting key concerns in their dissents. But instead of working to enhance competition in the AI industry and ensuring that proper safeguards are in place, they are forced to contest their blatantly unlawful termination by President Trump. This unprecedented power grab followed similar efforts to remove Democratic members of other independent agencies without cause. As one court noted, these efforts, quote, threaten to upend fundamental protections in our Constitution. But ours is not an autocracy. It is a system of checks and balances, close quote. Just as unchecked power by monopolies in the marketplace does not secure the best outcomes for consumers, unchecked government power does not secure the best outcomes for our democracy. We should be mindful of both points as we begin today's hearings. I look forward to hearing from our witnesses, and I yield back my time.
Gentleman yields back. I now recognize Chairman of the full committee, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. American innovators have always led the world because we've always protected free markets, limited government, and individual liberty. But when it comes to AI, the Biden administration turned its back on innovators and entrepreneurs. Rather than trusting American ingenuity, the Biden administration tried to put Washington in charge, empowering unelected and unaccountable bureaucrats. And who paid the price? The very people we should be empowering. The startups trying to challenge big tech, the researchers building open models, the platforms that actually support free speech. Meanwhile, around the world, we see the dangers of pursuing the wrong approach on AI innovation. We see China pouring billions of dollars into AI development to weaponize the technology. We see Europe smothering innovation with overregulation and impossible compliance burdens. We should be clear, America must lead on AI. But to do that, we need to protect free speech, preserve real competition, and get the government out of the way. That means, number one, no backdoor censorship. Number two, no weaponizing antitrust law to reward political allies and punish dissent. And number three, letting no international bodies or unelected regulators set the rules for American technology. Thankfully, President Trump, we have a president focused on unleashing American innovation, on cutting red tape, and on protecting free expression, and on making sure AI development happens here, not in China, not in Europe. Under President Trump's leadership, the focus is right where it should be, keeping America competitive, preserving free speech, and getting the government out of the way. Today's hearing is about how we protect innovation, protect liberty, ensure that AI remains a force for freedom, not for control. So I want to thank our chairman for calling this hearing, and I look forward to hearing from our witnesses. I yield back.
Gentleman yields back. Without objection, all other opening statements will be included in the record. We will now introduce today's witnesses. Mr. Neil Chilson. Mr. Chilson is the head of AI policy at the Abundance Institute, a nonprofit organization focused on emerging technology. He previously served as the chief technologist at the Federal Trade Commission and as an attorney advisor to then FTC acting chair Maureen Alhusen. Mr. Joe Coniglio. Mr. Coniglio is the Director of Antitrust and Innovation at the Information Technology and Innovation Foundation, where he leads the Schumpeter Project on competition policy. He focuses on digital platform, monopolization policy, and dynamic competition. Ms. Jessica Melugin. Ms. Melugin is the Director of the Center for Technology and Innovation at the Competitive Enterprise Institute. Her research focuses on technology issues, including antitrust, online privacy, artificial intelligence, telecommunications, and other issues. Mr. Alvaro Bedoya. Mr. Bedoya is a former commissioner at the Federal Trade Commission. Prior to his appointment to the FTC, he founded the Center on Privacy and Technology at the Georgetown University Law School. We welcome our witnesses and thank them for appearing today. We will begin by swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record reflect that the witnesses have answered in the affirmative. Thank you, and please be seated. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. Without objection, Mr. Kiglio will be permitted to participate in today's hearing for the purpose of questioning the witnesses if a member of the subcommittee yields him time. Please know that your written testimony will be entered in the record in its entirety. Mr. Chilson, you may begin.
Thank you, Chairman Fitzgerald. Thank you to the chairs and ranking members of the full committee and to Ranking Member Correa and distinguished members of the subcommittee. Thank you for inviting me to testify today. I'm Neil Chilson. I'm the head of AI policy at the Abundance Institute. We are a nonprofit dedicated to creating policy and cultural environments that allow emerging technologies to thrive and expand human prosperity. Last year, American AI startups raised more than $97 billion, or approximately half of the entire Apollo program. At least 49 different US AI startups raised more than $100 million just last year. These are record numbers, and they're just getting started. I'm here to make a simple but important point. Economically, AI isn't an industry or a market. It's an ecosystem of thousands of companies. And the US AI ecosystem is vibrant and remarkably competitive at every level. From chips to cloud infrastructure, from foundation models to applications, we're seeing intense competition driving rapid innovation and democratizing access to powerful AI capabilities. Consider that 11 different developers last year globally, across the globe, achieved a GPT-4 level model, one of the most advanced types of AI models. Or that market shares in cloud computing continue to shift with established players and startups pressuring each other. The AI enterprise service market is highly fragmented, with the leading firm holding a mere 7%. These are not signs of concentrated power, they're evidence of healthy competition. This competitive environment is spreading the benefits of AI widely. AI capabilities that were cutting edge or even unimagined just a few years ago are now widely accessible or even free. For example, many of you may have seen the most recent generation of Studio Ghibli themes online. This type of use of powerful image generation, which once required specialized knowledge and powerful computers, is now available for anyone for free or maybe pennies per image. AI services keep getting better and cheaper, with API access for the leading models dropping in price by 80 or 90% last year. Lower prices open up new use cases, empower small businesses, and new market entrants. Open source AI models are a particularly powerful vector of competition. Open models level the playing field, reduce barriers to entry, and give smaller players access to cutting-edge AI technology without needing massive resources to train their own models. And this sector is growing fast. Aggregator Hugging Face, which hosts more than 1 million different open source models for different purposes. And for the most advanced models, OpenAI just yesterday, announced that they will soon release an open weights model, joining major players like Meta and DeepSeek. The vibrant AI ecosystem in America does face a threat, however: miscalibrated regulation. Regulation often entrenches incumbent firms by creating barriers that new competitors cannot overcome, and compliance costs are disproportionately burdened smaller, newer firms, giving established players a competitive advantage. The Trump administration recognizes this threat of regulation and has shifted the federal conversation in AI from one that's based on fear to one that's focused on opportunity. And this is a welcome change. At the state level, however, there are more than 900 bills proposing to regulate AI, and they've been just introduced since January. While often well-intentioned, this emerging patchwork of regulation threatens to undermine both domestic competition and our national competitiveness. Congress should meet this challenge by creating a consistent national regulatory approach to AI that maximizes freedom for general-purpose AI technology while clarifying obligations in specific applications such as healthcare or transportation. There are more detailed ideas in my written testimony. In conclusion, the U.S. AI ecosystem is remarkably competitive and innovative, spreading access to powerful tools. To sustain this vibrant competition and to maintain American leadership, policymakers should clear regulatory barriers and resist raising new ones. By doing so, we can preserve the dynamic nature of AI and continue reaping its enormous economic and social benefits in the years to come. Thank you for your attention, and I welcome your questions.
Thank you, Mr. Chilson. Mr. Coniglio, you may begin.
Chairman Fitzgerald, Ranking Member Nadler, and Chairman Jordan, and esteemed members of the subcommittee. I'm honored to be here today. In my remarks, I'm going to highlight three key areas where I believe AI and antitrust overlap and critique three policy frameworks for dealing with AI. In my view, AI provides no reason at this time for either heavy-handed antitrust enforcement or changing fundamentally our antitrust laws. First, the AI industry is highly competitive and developing in a way that is consistent with the healthy innovation competition that typifies high-tech markets. Firms like NVIDIA reinvented themselves with huge success to lead and recoup their investments in chips, while a number of newer players like OpenAI and Anthropic are flourishing at the model level, in part due to partnerships with large digital incumbents. Indeed, not only is competition robust among cloud providers, it is a testament to big tech firms not resting on their laurels, but aggressively also competing at many levels of the AI stack. Second, AI is already being heralded as the next general-purpose technology that, like the internet, will transform our economy. And as the past 40 years make clear, the stakes for getting competition policy right are high. Whereas the U.S. pursued deregulation and a consumer welfare antitrust model that was conducive to the innovation and growth that helped preserve its share of global wealth amidst China's rise, Europe continued with an antitrust framework more suited to protected competitors, missed the digital revolution, and saw its share of global wealth fall by almost half. Importing a European-style competition policy to America risks repeating this mistake with AI and ultimately benefiting China in its own quest for AI dominance. Third is the question of how AI will affect the antitrust enterprise itself. For example, when it comes to combating collusion, some have suggested that AI algorithms may make it easier for firms to form and police cartel agreements, as well as facilitate oligopoly outcomes without any agreement and thus avoid antitrust scrutiny. On the other hand, not only has the Department of Justice already brought AI-related algorithmic collusion cases using its existing tools, which in the future could even be enhanced by AI technologies that make it easier to detect cartels, but AI may also increase firms' incentives to disrupt cartel behavior, resulting in less collusion throughout the economy. In the face of these complex issues, I want to now discuss three flawed antitrust enforcement approaches policymakers may be tempted to adopt. First is the idea that antitrust is more important than ever before. Some worry that AI will increase concentration throughout the economy by virtue of network effects and increasing returns to scale in ways that make it hard for markets to self-correct. These concerns, which are as old as the antitrust laws themselves, overlook the cost-reducing potential of AI, which also may lower barriers to entry for small and medium-sized businesses and create competition. Moreover, increased concentration not only isn't bad when it's driven by lower costs that reduce prices for consumers, but it often empowers the incentives and abilities that spur innovation. Second, there is the contrary view that because AI is so disruptive, there's little need to enforce the antitrust laws at all. Indeed, a similar debate was had during the internet revolution and noted in the seminal Microsoft case, where the court discussed how, in technologically dynamic markets, monopoly power may only be temporary. While, like the internet, AI is poised to bring tremendous benefits and disruption, the past 40 years have taught us to be wary of formalizing theoretical assumptions of market self-correction. Antitrust still matters, and we should continue to carefully examine market realities for anti-competitive conduct in the age of AI. Third, there is the notion that AI may undermine the very market competition upon which antitrust law is premised. Some commentators have claimed that AI may even render markets obsolete through more sophisticated calculation techniques that could make regulation superior. The central problem with this perspective is that it's based on a static understanding of how market competition works. More dynamic competitive processes will undercut the justification for state central planning and regulation in a way that reaffirms the importance of healthy, well-functioning markets. In conclusion, I think the right approach is to maintain antitrust law's traditional focus on promoting competition and innovation by prescribing collusive and exclusionary anti-competitive conduct. This has, since the passage of the Sherman Act, withstood and helped manage the creative destruction that worked to make America the world leader that it is today. Ensuring that competition policy remains tethered to these principles is essential for preserving American leadership into the 21st century amidst the new wave of general purpose technical change that is AI. Thank you, and I look forward to your questions.
Thank you, Mr. Coniglio. Ms. Malusian, you may begin.
Chair Fitzgerald, Ranking Member Nadler, and distinguished members of the committee, thank you for holding this hearing today and inviting me to participate. My work focuses on technology and antitrust at the Competitive Enterprise Institute, a nonpartisan public policy organization that concentrates on regulatory issues from a free market perspective. I am also an antitrust and competition fellow at the Innovators Network Foundation. I am pleased to have the rare opportunity to speak to you today about a bipartisan goal, that of ensuring the United States remains the leader on artificial intelligence technologies. While reasonable people can disagree about the challenges AI might bring, almost everyone recognizes the technology's vast potential for economic efficiency gains, life-saving medical breakthroughs, environmental benefits, and more. There is similar consensus around the importance of our country winning the global race for AI dominance ahead of various authoritarian regimes around the world, including China. This broad political agreement can be found in last year's bipartisan House Task Force report on artificial intelligence that emphasizes the economic and national security importance of AI's success for the United States. If all agree that a flourishing domestic AI industry is critical, we should next identify the biggest threat to continued US dominance in the field, namely government overreach. Alongside the growing patchwork of state-level AI regulations that I would encourage this Congress to consider preempting, but that's a whole nother hearing, the threat of overzealous antitrust regulation looms large. The default antitrust approach to AI in the US should be one of humility by regulators. However well-intentioned, antitrust enforcers are no better than anyone else in foretelling the future, and certainly not clairvoyants capable of accurate ex-ante regulation of a quickly evolving technology. Antitrust enforcement in the tech sector has been particularly poor, from an abandoned IBM suit that lasted 13 years to a Microsoft case where innovation in the market largely rendered the charges moot. Litigating antitrust in tech is especially challenging. We can look across the pond to the European Union for an even more cautionary tale in overregulation and excessive antitrust enforcement. The result is that in the US, with its relatively light-touch regulatory regime and consumer welfare-driven antitrust approach, we boast 8 of the top 10 global tech firms by market cap, with Europe unable to claim even one. Currently, the EU has an AI regulatory framework much larger than its AI industry, putting them on the now familiar path to diminished prosperity. We needn't make the same mistake here. We know what regulatory framework leads to success and can course correct for the harmful antitrust trends of the last 4 years. The embrace of a big is bad approach to antitrust enforcement at the prior administration's Federal Trade Commission and Department of Justice must be reversed. It's critical that America's AI ecosystem has both large, established firms with their vast resources for research and development and vibrant small startups with their nimbleness and innovation. In many cases, startups rely on the expectation of eventually being profitably acquired by large firms to secure early funding. This is why continued regulatory hostility to mergers and acquisitions is a recipe for stifled AI growth. We must also return to an economics-based approach to identifying competitive problems should they arise. Whatever challenges outside of measurable economic concerns AI might bring, antitrust law will be the wrong tool for correcting them. Refocusing enforcement on consumer welfare and away from ambiguous, vague social goals will be a productive improvement over the last several years. But what are the current facts on the ground for AI competition landscape right now? So far, competition seems to be thriving in what is a non-unitary market, from hardware to the data layer to algorithms and applications. The then newcomer OpenAI had a meteoric rise to popularity with its debut of ChatGPT in November of 2022, and is holding its lead over even the biggest established tech competitors as the most used large language model. Those tech giants plan to spend more than $300 billion this year investing in AI technologies, which is not the behavior one would expect from entrenched monopolists insulated from competitive pressures. And the presence of multiple open source models that allow the little guys to build on those already established models ensures beneficial competitive pressure and leaves space for innovation. The current state of competition in AI is strong. The threat of premature and unwarranted antitrust intervention poses one of the greatest threats to global US competitiveness. Thank you for this opportunity to testify, and I look forward to your questions.
Thank you, Ms. Malusian. Mr. Bedoya, you may begin.
Thank you, Chairman Fitzgerald, Ranking Member Nadler, Chairman Jordan. Members of the subcommittee, thank you for having me here. Right now, people think that a successful AI startup needs 4 things: chips, cloud, training data, and the people to train those models and deploy them. And so right now there are races being run to secure access to those 4 key inputs. In the time I have with you today, I want to issue 3 warnings about those races. First, I want to warn that certain agreements between major AI developers and 2 of the biggest cloud service providers may be limiting the availability of those cloud providers to those smaller, innovative startups. Just this January, FTC issued a staff report. We looked at 3 partnerships between the major cloud providers and the major AI developers out there. The report showed that cloud providers typically got things you'd expect: equity, a share in revenue from those AI developers. The agreements also required the AI developers to spend a lot of the investment from the cloud provider on cloud services from the cloud provider. Now, unfortunately, these kinds of terms may be incentivizing those cloud providers to limit access to their platforms away from AI startups who they're not partnered with. And unfortunately, this is not hypothetical. There was actually an internal document from one of those cloud providers that said, quote, "We are unable to serve a growing number of startups who need bursts of graphics processing unit capacity to train and release their models." So I agree, we want a world where a scrappy startup can eat a powerful incumbent. But we have to ask if these kinds of agreements, this kind of vertical integration, is leading us away from that kind of innovation. That's the first warning. I also want to address the race to collect and retain data, because in the race to scrape, buy, access all kinds of human-generated data, I'm afraid that a lot of AI developers are collecting and keeping data that a lot of us would consider deeply private. So here's an example. In 2023, the FTC alleged that by default, Alexa was keeping recordings of kids' voices forever. And it wasn't just that. Even when parents said, "Hey, Alexa, I want you to delete that," Alexa wasn't doing that. It was actually keeping the transcripts of that information. Now, anyone who's a parent should stop and ask themselves, what on earth does my kid need to say to a smart speaker for me to stop everything and say, "Oh no, we need to delete that data"? But that's not what happened. Here's the key thing, though. The FTC alleged that one of the reasons Amazon gave for retaining that data was their need to train their voice recognition algorithms. And so that's my second warning. We have to remind companies that the need to train your algorithm doesn't override the need to follow the law, including privacy law and kids' privacy law. Here's the third and last flag. There's been a lot of attention, and I think for good reason, paid to the apparent collection and use of copyrighted works to train models. My colleague, Mr. Chilson, mentioned the Studio Ghibli algorithm that's out. I'm afraid we aren't paying enough attention to the collection and training of training data about people who are in no way famous, working people. Let me give you a quick example. During the actors' strike, a prominent director, Justine Bateman, posted online asking if any extras, these are folks known as background actors, if any of them had ever been asked to submit to body scans on set. And suddenly these stories started pouring in, people saying, "Yeah, I got tapped on the shoulder, I was told to go to this tent, and I stepped in there and I was scanned 360 degrees, head to toe. And I asked why, they didn't tell me. I asked if I was gonna get paid, they didn't give me anything. But the few people who found out were told, oh yeah, this is to add you in later if we want to, of course, at no additional pay." I'm talking about this because scanning people at their jobs to replace them at those jobs is becoming common outside of Hollywood. So this is starting to happen in customer service call centers. These are jobs that used to provide high school graduates a path to the middle class, but now they're rife with surveillance. And a lot of that surveillance appears to be aimed at recording the best performers to create algorithms that are marketed as replacements for the workers at those call centers. So in closing, I'd respectfully urge the subcommittee to not just look at competition between AIs, but competition between AIs and workers, because it raises some pretty fundamental questions like, how do you compete with a digital version of yourself who can work 24 hours a day, 7 days a week with no break, no vacation, no benefits? Is it fair to force you to train your AI replacement? Is it fair to force you to do it without your knowledge? And as I explained in my testimony, I think this is a great reason to pass a workplace privacy law. Thank you again, Mr. Chairman, Ranking Member Nadler, for the opportunity to testify. I'm glad to answer any questions you may have.
Thank you very much, Mr. Bedoya. We'll now proceed under the 5-minute rule with questions. I'm going to recognize myself. In recent remarks at the AI Summit in Paris, Vice President J.D. Vance stated that AI presents the extraordinary prospect of a new industrial revolution. But it will never come to pass if overregulation deters innovators from taking the risks necessary to advance the ball. He was referring to the European Union's Digital Markets Act and AI Act. Ms. Malusian, why would replicating Europe's heavy-handed regulation of AI in the U.S. Certainly be maybe unwarranted or even premature?
Yes, it's kind of the European Union to have run this experiment for us. It has not gone well. Their first big attempt at digital regulation, the GDPR, ended up hurting the entire industry, but mostly hurting the little guy disproportionately, which we would see the same of here with a lot of the regulatory moves. The big entrenched accused monopolists or just market leaders, depending on your perspective, might have the resources to comply with a lot of those regulations, but the runway is not clear for the next big success story. And that's what you have to keep in mind, that a lot of times the companies that have a seat at the table might be able to make this work, but we don't know what's being developed in someone's garage right now that could be the next big thing. And I think that goes to the general approach in Europe, which has been that if you're chilled in your innovation by worrying that everything you do, every new business arrangement, every new idea could be running afoul of one of the many, the DMA, the DSA, the GDPR, it just has an overall chilling effect on that industry. And of course, relatedly, on investment in that industry. And frankly, the US really doesn't have that time. If China, I don't think it's an overstatement to say they're nipping at our heels in terms of the AI race. And what those companies and those industries are doing in China, is not the regulatory framework you see in the US, but it's also very much not the one you see in the EU. And it's no coincidence that you find all three of those segments in a different order of success. And we want to make sure we keep ourselves out front. As I said in my testimony, the European Union doesn't have one of the top 10 global businesses. And again, that's not to say that the small companies aren't important too to develop here in the US, but you certainly need the scaling abilities of large companies, the research and development resources of these large companies. You want a healthy ecosystem with the big guys and the small guys. And adopting a European approach won't allow that to happen at either level here in the US.
So the Netherlands-based software firm Bird, which has been recognized kind of globally at this point, is moving out of the EU as a direct result of the AI Act. What they said was that Europe regulators are just killing the innovation within the EU. So you think there's lessons already that can be learned here in the States from what we've witnessed on some of these examples of what's transpiring overseas?
Yeah, I don't even think you have to abstract very much. I mean, the EU AI Act that those regulators bragged about being the first to regulate AI, which to some of our ears doesn't sound like something to brag about, means that a lot of the US companies that rolled out AI products that consumers have found incredibly useful, have been very popular here in the US, they were delayed in Europe because they weren't sure that they could comply with all the rules and regulations. So at the worst case scenarios, you don't get those innovations, your constituents don't get those services and those tools. The best case scenario is that they're delayed because of regulatory overview. And again, that's an example where the little guy who's innovating something new maybe doesn't have the team of lawyers that the big guys do. So I don't think we want to set up that dynamic here in the US.
Very good. Mr. Coniglio, you just cautioned against overregulation in your testimony. You note that robust antitrust enforcement to promote customer welfare and innovation should remain a policy focus. Can you just elaborate kind of further on that point?
Absolutely. Thank you for the question. Ms. Malusian pointed out the lessons we learned from regulation, and I would note the U.S. also has some lessons that it learned from deregulation about how deregulation can spur economic growth and innovation. But there's also a very important story to tell regarding competition policy, and specifically two different approaches that were taken over the past 40 years between America and Europe on competition policy. And at a high level, Europe's approach was very much focused on protecting competitors. So it wanted to see markets where there were a lot of small firms. America's approach was focused on not condemning size in and of itself, but focusing on consumer welfare and innovation. And I think if you look most recently at the Draghi report that was issued in Europe, it was very clear that the digital revolution that happened in America has really driven the productivity gap between the United States and Europe that's occurred. And I think antitrust is not the sole reason for that, but I think it's part of the reason. Because if you have an antitrust policy that's not conducive to innovation and consumer welfare, and instead focusing on protecting small competitors, you're not going to see the sort of dynamic innovation competition that's really driven the digital industry in America, and which in part can large firms can also play a big role in driving that innovation.
Thank you very much. My time has expired. I'm going to recognize the ranking member, Mr. Nadler, for 5 minutes.
Thank you, Mr. Chairman. Commissioner Bedoya, one of the many areas in which the Federal Trade Commission has distinguished itself is in its groundbreaking activity to combat anti-competitive practices in the pharmaceutical industry. Whether it's the pay for delay cases or efforts to fight misuse of the FDA publication called the Orange Book, the FTC has been at the cutting edge. That's why I was so disturbed to see that yesterday, the FTC's general counsel stayed the administrative adjudication of the commission's case against the 3 largest pharmacy benefit managers over the price of insulin. The effort to bring down prices for consumers is just one example of the work you were doing before President Trump attempted to remove you from office. Can you explain the costs to be borne by consumers associated with the president's unlawful attempt to fire you and Commissioner Slaughter?
Thank you, Ranking Member Nadler. Maybe I can just talk about this case. So I'm pretty sure everyone in the room cares about the cost of insulin. And this is a case where FTC staff is alleging that these pharmacy middlemen, they're called PBMs, pharmacy benefit managers, are competing not to lower the price of insulin, which is how markets normally should work. They allege instead that these pharmacy middlemen are competing to raise the price of insulin. We, Commissioner Slaughter, who I'm joined...
Competing or colluding?
Pardon me? I didn't hear the first part of you.
Competing or colluding?
What was the first? Beating or colluding?
Competing.
Or
colluding.
The allegation in the complaint is there's a competition to raise the prices. I'm joined by Commissioner Slaughter. She and I are the only judges who are presiding over that case in an appellate manner, because our colleagues, Chairman Ferguson and Commissioner Holyoke, are both recused. And so now that it's the administration's contention that we are removed, there are no judges to adjudicate that case. And so the pharmacy middlemen have moved to stay it. That stay was granted, that request for stay was granted yesterday, and this case won't be adjudicated for at least another 105 days, so I think that's 3.5 months. And the evidentiary hearing, I understand, will occur even later. But basically, it's permanently, not permanently, but indefinitely on ice. And I don't think anybody wins from having a case like that not adjudicated.
Thank you. We know that, unfortunately, one of the ways new technology is deployed is to find ways to break the law. Is computer-generated pricing or algorithmic pricing being deployed to violate the antitrust laws, and what can the FTC do about it?
One of the things we're hearing a lot are allegations that instead of outright colluding, to use your term, just sitting down in a smoky room, like the Beef Trust did in Chicago, in the early 1900s, and just set prices. What a lot of competitors are doing is saying, oh, no, we compete, but we happen to use the same, algorithmic pricing software. And although there are allegations, for example, in the RealPage lawsuit from DOJ that they are in fact also picking up the phone and just straight up colluding, increasingly what you see are cases where they just use the same software. And so I think this is absolutely a core concern. The FTC has issued various requests for information around aspects of this. We issued an interim report around algorithmic pricing in January, and it's something I think we need to continue to track closely.
Thank you. We all recognize that AI carries with it enormous potential as well as possible perils. We also all recognize that it's a field that continues to develop, often at a rapid clip. Can you explain why the FTC's involvement in evolving industries, even while they're undergoing changes, is a good thing?
Absolutely. I understand folks who say, you don't want too aggressive antitrust enforcement. That's a bad thing. But for me, the case that jumps out is the case you mentioned, the proposed NVIDIA-ARM merger. NVIDIA is a chip supplier. ARM is a chip designer. It's a vertical deal. ARM was valued at the time of that deal for $40 billion. FTC sued. They dropped that merger. And as of like 9:58 this morning, ARM was valued at, I think, $114 billion. And so the answer to your question, Congressman Nadler, is that so the market can continue to evolve, so that scrappy startup can access all of these critical resources that the companies like these provide without the limitations like the ones I referenced in my opening statement, where their incumbents are getting locked in and startups are getting squeezed out.
Thank you. And finally, our fields of law, all fields of law can and should evolve over time. In recent years, there has been increased attention as to how competition affects not only consumers, but also workers. With that perspective in mind, how should we be thinking about how AI might impact the American workforce?
I would say the biggest thing people are not talking about is the need for some kind of protection for workers in the workplace, so that they just can't be scanned head to toe and replaced by algorithms. And this isn't no longer a thing from Hollywood. This is something you're seeing in jobs like call centers, online therapy, et cetera.
Gentleman's time
Thank
is
you. My
expired.
time has expired. I yield back.
Now recognize gentleman from Texas, Mr. Gooden.
Thank you, Ms. Malusian. The Biden administration passed sweeping executive orders on AI, which weren't authorized by any congressional action or directive. Do you think the previous administration bypassed Congress and micromanaged AI development without public accountability?
Yes.
Would you like to comment further?
Sure. I do. I think that it's a perfect example of the rush to regulate. What you all are doing here today is having a very constructive conversation about one aspect of AI, and I think that's to be applauded. I think coming out with an EO that puts large restrictions on how people are allowed to innovate, testing, rules that haven't really been put through either the common law process in the courts or a congressional process, I think is always a mistake. Even if I had agreed with the rules that were there, I wouldn't support it. But I didn't, and I think the lifting of that executive order with the current administration is generally a very positive step.
And so what role should Congress play in your mind in ensuring that AI governance reflects competitive neutrality, market dynamics, and constitutional accountability?
As I somewhat snarkily mentioned in my testimony, I do think that the biggest thing Congress could do would be to consider preempting the rush of state regulations on AI. I think there's very well-intentioned state legislators. They see that Congress isn't moving on this. They want to do something. But a patchwork of potentially 50-plus different regulatory regimes for AI is the kind of hurdle that could really slow U.S. innovators down, and certainly not the kind of hurdle that they're facing in China. So I think it's a infinitely unpolitically satisfying answer, but I think federal preemption should be something serious lawmakers consider. And what I think, to the antitrust question that we're talking about today, let's wait and see until what problems arise, and also what laws and tools are already on the books that regulators and lawmakers can use to react to those problems. Price fixing is still price fixing, whether it's done in a smoky room with meat, which actually sounds kind of great, the meat part. The meat wasn't, okay. It was a good visual, though. I want to give you full credit for that. Or done with AI technology and an algorithm. These things are still illegal. Fraud is still illegal, whether it's whatever kind of technology you use. So I think taking things on a case-by-case basis is a smarter approach to not making the mistake of over-regulating and hurting innovation in the U.S.
You mentioned China. Do you feel, where do we rank in terms of attracting investors, and are we doing better or worse than China with respect to AI?
Well, I think the structure is so different, right? It's private investment here in the U.S. for the most part. But China is pouring billions of dollars into these technologies. And I do think that without tying one arm behind our back, my money's on the U.S. to out-innovate always. But I do think that state patchwork of regulations or unwarranted and overzealous antitrust intervention could put us at a real disadvantage. And I think it's like we've been saying, there's different points along the AI ecosystem, so it's hard to give you one answer about all of it, but it's a close race.
Thank you. Yield back.
Gentleman yields back. Gentleman from California is now recognized for 5 minutes.
Thank you, Mr. Chairman. I want to welcome our witnesses today. You know, every day in the newspaper, something new with AI, new developments, new companies, competition, innovation, medicines, new medicines, drug developments, manufacturing, supply chains, a lot of good stuff. But I do believe we need guardrails. But they have to be guardrails that don't harm innovation or harm American firms. The U.S. right now, we, the United States, still lead the world. Used to be by a couple of years. Now I think it's maybe 2 months, maybe a couple of weeks compared to China. Mr. Chilson and Mr. Coniglio, if I can ask each one of you a yes or no question. Gentlemen, would you say that university research played an enormous role in developing AI? Yes, no?
Yes, over the 40 years.
Mr. Coniglio?
Yes, I would say the same.
If you look at this chart, you can see that is in fact true. I know private companies are developing and investing in AI, but second question, gentlemen, the future workforce training, that AI workforce, research still happening at universities, correct?
I think some of it, lots of companies
Some of it?
also.
Okay. Mr. Coniglio?
I would agree.
So if we cut off funding for university research today, are we damaging the American pipeline? Students, future students who become leaders in AI, fundamental research, are we hurting ourselves by cutting off university research funding? Mr. Chilson, Mr. Coniglio, yes, no?
I'm honestly not sure.
Mr. Coniglio?
I would certainly say that funding from universities is very important to drive innovation, and that's true generally.
And I say that in the context of our main competitor, which is China, which are essentially doubling down their investment in this area. I think that's well established, that's well known. Now let's look at this chart of some of the top AI companies. Data from 2023. Many of these firms are started by immigrants. This is in 2023. Can you imagine the number of immigrants started AI firms for 2024? Probably a whole lot more. And this doesn't even reflect major tech started by Sergey Brin of Google or Elon Musk. So, gentlemen, another question for you. Do you agree that immigrants have played a huge role in developing and advancing technology and AI sectors? Yes, no?
Absolutely.
Mr. Coniglio?
Yes.
So this country, we really want immigrants in this country who can contribute to innovation, and we don't want to scare them away. Have them go to Canada, China, India, not even come to this country. Would you say that's yes, no, Mr. Chilson?
America is the best place to do AI in the world.
Mr. Coniglio?
I would agree. We need to keep America an AI leader and use all tools we can to make that happen.
Because over the last 50, by more like 100, 200 years, America has always attracted the best and brightest from around the world because they know opportunities in this country exist. So I agree that overregulation, misplacement of antitrust enforcement can harm AI, can harm this country's companies as they seek to compete with China. But I'll tell you, looking at this administration's policies of cutting research funding to universities, scaring immigrants away from studying or creating new companies in the US, creation of unstable markets through tariffs, these three factors, in my opinion, are going to hurt this country even more. Long-term damage to our leadership, our economy, and our future. And I do hope we begin to focus on what's made this country great, what helped us in the last 50 years, innovating, leading the world, because we can't afford to lose the AI race. Thank you very much, Mr. Chairman, and I yield.
Gentlemen.
Before I do, can I add some articles for the record?
Gentleman's recognized.
Chairman, I'd like to ask unanimous consent to introduce the following articles. First, China's top universities expand enrollment to beef up capabilities in AI. Second article, 65% of top AI companies have immigrant founders. Article number 3, Trump's science policies pose long-term risks. New York Times, March 31st. Fourth article, Trump administration has begun a war on science researchers. New York Times, March 31st. Fifth article, China leads the world in generative AI adoption. Sixth article, former Google employees create 14 of the top 50 AI startups. Seventh article, Trump loves AI, but his terrorists ramp up costs for data centers. Article number 8, Apple chip engineers return to China, joins Fudan University amid push for talent. Article number 9, immigrant entrepreneurs bring jobs and innovation. Forbes, May 23rd, 2024. Article number 10, from underdog to genius, Yale computer scientist Sun Huanbo returns to China. Article number 11, tech companies are telling immigrant employees on visas not to leave the U.S. Thank you, Mr. Chairman.
Without objection, the gentlewoman from Wyoming is now recognized for 5 minutes.
Thank you. China is trying to control the global AI sector through extensive state-directed investments, aggressive subsidies, and protectionist trade measures. It is making substantial investments to secure its global position through initiatives like Made in China 2025 and the New Generation Artificial Intelligence Development Plan. Mr. Chilson, how might China's government subsidies and protectionist policies affect global competition in AI?
So China's model for AI innovation is very different than the US's. It's largely state-sponsored. It is driven through a structure that is designed to make sure that the Chinese Communist Party has its finger in everything. And it means that the end result is a design from the top ecosystem. They pour a lot of money into this, and they have talented people, and so they do have surprises occasionally. The DeepSeek AI model that came out, they can get a lot done with that model. Ultimately, however, I think the U.S. model, if we don't, tie one or both hands behind our back, is going to win in this space because we have the talent, we have the investment, and we have the ecosystem that rewards trying new things out and seeing if they work. And so I worry a lot about China. I think modeling and this is why I was a little bit confused about the university question, a top-down investment model that tries to look like China is not the right model for the U.S.
I'm glad to hear that, and I'm also excited to hear about your optimism. Because what would be the strategic consequences if China achieved dominance in the global AI space?
Well, there's a lot of different consequences, and we could just look at cultural ones. We could look at strategic national security ones, and I think those are the ones that I think raise the most eyebrows. This
Can you give me some examples?
Yeah, so this technology is very powerful, both in an offensive and defensive manner for cybersecurity. So both to defend from cybersecurity attacks and to cause them. And so Being ahead in that race matters a lot. A lot of our infrastructure in the U.S. obviously needs to be strong against those types of attacks, and I think that AI has a huge potential to be a defensive barrier to those types of things, but we need to stay ahead in the race.
Well, I agree with you on that as well. This committee has observed with concern harmful policies also coming from the EU on privacy, antitrust, censorship, and more. Now the Artificial Intelligence Act will impose significant compliance costs on affected companies, particularly American businesses that play a pivotal role within the AI sector. Mr. Coniglio, how should we as members of Congress be concerned about the impact of this framework on our constituent businesses? And are there specific ways in which the EU regulations might disadvantage smaller American AI companies as compared to larger firms?
Thank you very much for the question, Congresswoman. I would say we should be very concerned about the regulatory approach that the European Union is taking, not just with the AI Act. One of the things I would say they did learn from the GDPR is now to do regulation that targets American firms specifically so that they don't burden their smaller firms with regulation. And that's really been the lesson with the DMA, which is absolutely disproportionately having very harmful effects on American businesses, really our tech leaders. And it was intended to do so. So I think that, as I recall, a letter from Chairman Jordan starting to investigate those practices is very important and something we need to continue to do.
So do you have recommendations as to what Congress specifically ought to do in this space?
It's a very complicated area. I would note, with respect to potential legislation, in Korea, there was a proposed bill by Representative Miller, I believe, to talk about potential tools in a trade area that could be used to the extent that regulations are being basically weaponized as de facto protectionist policies against American companies. And I think that might be absolutely be the right framework to think about it.
Okay. Mr. Chilson, in your testimony, you cite how competition is robust and global across all layers of the AI stack. How should Congress consider protecting American companies in such an environment, or is such a policy even achievable or worthy of consideration?
So American companies lead the world in this, so I don't know that they need protection from Congress, but what they do need is the ability to continue to innovate, build, get the supplies and the data that they need. And there's a lot in the regulatory space that Congress could work on. I think in particular, we've mentioned it a couple times, but one of the biggest threats is well-intentioned, but often very abstract and not well-developed state-level regulation, which could limit a lot of this innovation.
So preemption is important.
I think it's very important.
Thank you, and I yield back.
Gentlewoman's time has expired. Now
Mr. Chairman, I have the unanimous consent request.
Gentleman is recognized.
Thank you. Mr. Chairman, I'd like to enter into the record an article, AI Watch Global Regulatory Tracker, that details how many more regulations than the U.S. does on AI development and deployment.
Without objection, the gentlewoman from Vermont is now recognized for 5 minutes.
Thank you, Mr. Chair. Commissioner Bedoya, thank you so much for being here, and Commissioner Slaughter, it's really nice to see you. Commissioner Bedoya, as commissioner at the FTC, I think your experience on competition, artificial intelligence, and how these things affect everyday people is extremely important to this discussion. And we all understand that we're in the early days of what may be a massively transformational technological moment. It's plausible that this may be like the emergence of the internet, the mobile phone, or really even electricity. But it's so important that we don't lose sight of the central point here, which is how does this technology help or hurt working people? That's what I'm focused on. Commissioner Bedoya, you spent a great deal of time as FTC commissioner outside of DC, traveling around the country, hearing from people. And I want to know, have you heard a sense of concern from people, working people, about how AI is impacting their lives?
Sure. So I confess a lot of my roundtables have focused on, groceries, pharmacy, that kind of thing.
Everyday costs.
What's that?
Everyday cost.
Everyday cost, that's right. I will say a couple things on this. A lot of people look at what happened around the actors and writers' strikes, and they say, oh, that's just a Hollywood thing. But entry-level actors and entry-level writers don't make that much money. And you had situations where people were quite worried, and with good reason, that the cost of selling your first script was going to be to submit, all your work to be fed into one of these AIs, so that there would be no need to hire you in the future. I also do think there have been a lot of concerns. I think my colleague Commissioner Slaughter has done a roundtable on this, on the use of price-fixing algorithms in rental housing markets.
That's where I'm going.
Yes, and that's a real concern.
That's exactly where I'm going. Let's jump to that, because this is a deep concern of mine. Could you tell us in real terms, because you had talked about earlier that it's not just the algorithm itself in terms of RealPage, but there seems to be instances that we can look to. There seems to be evidence that there is actually some collusion happening here. And that's something that I'm deeply concerned about, and we all should. There is a crisis of housing in this country, and renters are over a barrel right now. They don't have a lot of options. So can you talk a little bit about how this is impacting regular people just in terms of trying to afford their rental housing?
Sure. So the allegations in the space are that these algorithms don't just offer the exact right amount of an increase so that a renter swallows the increase rather than tries to find a different place. There's allegations of actual overt in the RealPage lawsuit, calling between landlords to coordinate. But there's also allegedly information sharing, creating a pool of data that these landlords can draw on to increase rent without saying, while being able to say, oh, we never called each other. One really interesting point here is sometimes antitrust harms, because they're a little complex, can get a little technical. Mm-hmm. I'll just point out that one of the corporate landlords in the RealPage suit is a company called Greystar. FTC is also simultaneously suing Greystar for packing people's rent checks with these fake hidden fees like, oh, you want no cockroaches in your apartment? You got to pay extra for that. And so
pay extra for no cockroaches, huh?
Precisely. And so you see, anti-competitive conduct arm in arm with conduct that hurts consumers, in my view, pretty obviously.
So I do think it's important in this hearing, as we talk about the importance of not stifling innovation, to at the same time be able to hold both truths. We can be careful in our regulations. We can be careful in the guardrails that we're putting on, but I don't think anyone here, at least I hope not, that anyone on the Antitrust Committee would be supportive of landlords colluding to raise the price of rent. And I know in some instances we've seen that this AI dynamic pricing scheme has led to increases of over $800 over the course of a year, of not just these hidden fees that we're talking about, but the prices that they're paying for rent itself. And of course, you've talked about how essential workers are being replaced in key industries, where we see patients illegally being denied care because of an AI-based recommendation, where artists are being robbed of their work. And I just have to say, we have got to remember the importance of following the law when it comes to having FTC commissioners. And I think it's outrageous that you and Commissioner Slaughter were illegally removed from your positions. We need you on the watch to take care of my renters back home in Vermont who were being screwed over.
Gentlewoman's time is
I yield back.
Gentlewoman yields back. I now recognize the gentleman from North Carolina, Mr. Harris, for 5 minutes.
Thank you, Mr. Chairman, and thanks to all of you on the panel for being a part of this hearing today. On January 23rd, 2025, President Trump issued an executive order titled Removing Barriers to American Leadership in Artificial Intelligence, aimed at solidifying the United States' position as the global leader in AI. I, for one, applaud the Trump administration's leadership on this issue. Mr. Chilson, would you just take a moment and explain how this executive order will indeed help solidify our position as the global leader in AI, as the EO states?
Well, it's a sea change from the Biden executive order, which was the third longest executive order in history, and basically set a government-wide call for agencies to figure out how to regulate AI. This Trump executive order is the opposite. It's focused on figuring out how can we create the opportunities, or how can we maximize the opportunities from this amazing technology, which is grown here in America. And so some of its mechanisms, it directs the Office of Science and Technology Planning to create an AI action plan. Those comments have gone into that agency, and I think they're going to come out with a comprehensive approach. But the main thing here is the total change in perspective. It's one from fear and risk that this technology is going to hurt people to recognizing that it has huge opportunities, not just for consumers, not just for everyday things that they use, but also, I think, in creating a lot of competition in the AI industry, but also across the economy as a whole.
You referenced the science and technology policy. I know Section 4 of Trump's executive order requires various executive agencies to coordinate on the creation of an action plan to submit to the president in 180 days. And the action plan should lay out how we can achieve AI dominance. So you and your colleague, Mr. Chilson, understand that the Abundance Institute submitted recommendations to the Office of Science and Technology Policy on what should be included in that action plan. Could you take just a moment and summarize what your recommendations might be?
Right. So at the very top, I think you've heard this concern repeatedly across this hearing. Is stemming the tide, the flowing tide of state AI regulations. What we have right now is a set of regulatory schemes that regulate from the very top, the most abstract level of AI, these general purpose models. It's a general purpose technology. It can be used in millions of different ways. And states are trying to say that these companies have to make sure that that model can never be used in a way that might hurt somebody. And that's the type of regulation that is not only impossible to comply with, it will be impossible to enforce as well. And so I think that Congress needs to look at this, the White House needs to look at different ways to stem this tide, whether through the bully pulpit or proposing legislation to Congress that will help stem that flow. I think it's a big challenge, and Congress and the White House need to step up to that.
Well, let me ask you this. Can Congress play a role in helping the United States achieve the goals that have been set forth in the executive order?
Absolutely. I think it will be essential that Congress does so.
Okay, and are there any legislative efforts that will bring us towards the vision set forth by the Trump administration?
Well, I think there's a lot of different models we could take. One state action that has been very useful, Utah has an AI Act that creates a AI learning laboratory where people can come in, get regulatory mitigation when they don't understand fully what the risks are because their technology is new. And both the legislators and the company can learn together. So the most recent example of this was a technology that creates, it's an AI mental wellness app for teenagers, a really important problem. You can understand the sensitivity there. They worked with this regulatory sandbox to create not only just the app itself, but also there's been legislation that was proposed to Utah to the legislature that governed some of those types of apps. And so it's a cooperative thing. I think it's a kind of structure that might work very well at the federal level as well.
Very good. Well, thank you so much. Mr. Chairman, I yield back.
Gentleman yields back. The gentleman from Illinois is now recognized for 5 minutes.
Thank you, Mr. Chairman, and to all the witnesses here today, to Commissioner Slaughter for also being here to observe the proceedings. As usual, so far in this hearing, it looks like my colleagues, the Republican side of this panel, is here to champion corporate interests over workers and consumers. Today, their obedience is making them argue against even reasonable regulation of the AI industry. While not surprising, it's still incredible to see them making these claims with a straight face, given everything that's going on. Let's start with the fact that the Trump administration and its billionaire overlord Elon Musk are weaponizing AI to carry out their lawless and unpopular agenda. They're using AI to arbitrarily surveil students, expand the power of DHS and ICE, and gut federal agencies. In the hands of billionaires and authoritarians like Musk and Trump, AI is a loaded gun waiting to be used on immigrants, workers, and consumers. This is exactly why it's absurd to oppose common sense regulation of the AI industry. Let's talk about what that common sense could be. It's also absurd because we know what happens when we don't enforce antitrust and consumer protection laws against technology companies. As my colleagues have pointed out, the failure to apply these laws to big tech companies at the dawn of the social media age has led to the dominance of these companies, which has routinely abused workers, exploit consumers, and deployed their technology to expand surveillance and trample on privacy rights. That is the consequence of inaction. We must learn that from our mistakes, and we must prioritize workers and consumers over corporate profits. So let's talk about what that looks like. Commissioner Bedoya, thank you for being here today. I stand in solidarity with you as you face Donald Trump's illegal efforts to fire you and Commissioner Slaughter. But can you talk about the competition between AI, if it exists, and workers, and the implications for labor rights?
I was down in Biola Battery, Alabama, a couple months ago, and there was a case from Pascagoula, which is right near there, of a call center worker who had a high school diploma, a single mom, and she had been able to take this job and find the middle class. She bought a house, nice neighborhood, great schools. And what was starting to happen is that there was this AI transcript that was being generated of her calls, but it was wrong. You know, people on the Gulf, you know, my wife's from Louisiana, have a different cadence, different accent slightly, and the AI-generated transcript was failing, and she would get docked for those errors. And one of the things she openly wondered was, because there was also other software operating that the workers thought was going to be used to replace them. She openly wondered, am I training my replacement? So these are the kinds of folks who may be hurt by these efforts to scan, track, surveil, swallow up all this data about people working really important jobs that might be used to replace them.
Thank you for sharing that. And based on your work at the Federal Trade Commission, what kinds of protections do you think are needed for workers if Congress were to act?
So I've already mentioned the need for a workplace privacy law. The other thing we urgently need, in my personal view, is some kind of guardrails against automated management. Increasingly, you're seeing allegations that people are getting fired automatically on the job because of the way they were tracked. Maybe it thought that they were just loafing around when they were actually going to the bathroom, when they were actually repairing the machinery on the warehouse floor. You also see instances where people are increasingly having their emotions analyzed on the job. This is another call center example. There was an AI that set off this emotion distress alarm anytime the caller at the end of the line started laughing. And so you have technology that doesn't work as well as people think it does, being used to fire people, dock their pay, and there need to be guardrails around that kind of conduct. Labor unions have often succeeded in putting those protections in place, but I think everyone needs those kinds of protections, not just folks who are lucky enough to be in a union.
Thank you, and my time is exhausted, Mr. Chairman. Before I turn it back, I seek unanimous consent to submit an article entitled, thank you, Open AI Peels Back ChatGPT Safeguards Around Image Creation.
Without objection. Gentleman yields back. Gentleman from Virginia is now recognized for 5 minutes.
Well, thank you, Mr. Chairman. My goodness, after hearing my friend from California talk, I'm reminded of the old adage, when you're a hammer, everything looks like a nail. And when you're a pro-regulatory Democrat, every industry, every opportunity to regulate means drive right in and regulate. Ms. Melugin, can you speak to what would happen to the AI industry if the U.S. were to adopt heavy-handed regulations? Which country are we in competition with right now that would take advantage of that and further run away with development in AI?
I think if American innovators are sufficiently distracted with regulatory hurdles and legal concerns, you are taking a limited amount of energy and resources away from them turning out the best product. At that point, the alternative for much of the world will be Chinese products. So the meta question to keep in mind is, do you want the world building on US-based products or China-based products? That's not to say that the illegal things that happen in relation to AI shouldn't be addressed, I think in large part due to already existing law, or that Congress might not consider new privacy legislation. Those are all things that can be considered when problems arise. But it's important to not lose sight of what we're here to do. I don't think that most Americans are looking for AI to be really, really regulated. I think they're looking for AI to be really, really prosperous and successful.
Well, to that end, China has a long history of intellectual property theft, particularly in AI and semiconductor technology. How can the U.S. better protect its AI industry from Chinese espionage? And should we be more aggressive in sanctioning Chinese companies that benefit from stolen IP?
You know, I think this sounds obvious, but to the extent that all of that can work, I think that's great. But I think at some point, if you're dealing with bad actors, the way to win is to win. And I think that you make the biggest mistake by hampering the efforts of US innovators with all this sort of the sideshow of all the things that can possibly go wrong. Of course, there are going to be challenges and harms that are very real. People's jobs will be replaced by a certain amount of automation. I will point out that that has been happening since the dawn of time. It doesn't mean we don't need to have real attention paid to those circumstances, but it's not worth holding an entire country back in the kind of technology that will benefit every single American and people around the globe, hopefully from AI products, because we can think of examples of someone losing their job. It's a tragic situation for that individual, but I would hope that the overall benefit to the economy and to society and prosperity of Americans compensates in some way for that churn. That churn is real, but we can't use those examples as an excuse to hamper an incredibly important technology.
But at the same time, you have big tech companies arguing that scraping copyrighted material for AI falls under fair use. But this practice could severely undermine artists, journalists, and content creators. Should the U.S. continue to enforce its protections to prevent AI developers from profiting off stolen intellectual property?
I think intellectual property with the forward movement of technology is a bit of a moving target. I think it's certainly an area where Congress can look to revisit and adjust as necessary. I don't know that we're there yet, but I think that those are very valid concerns. I'm certainly not here to argue that there will be no regulatory or legal reaction to AI. I'm just here to argue that it's better to go cautiously forward on a case-by-case basis, and fair use and intellectual property might very well be one of those.
Now, several lawsuits, including the New York Times versus OpenAI, argue that AI models unlawfully use copyrighted content for training. Given these legal challenges, do you think courts will ultimately force AI developers to pay licensing fees? And how might that impact competition and innovation in the AI industry?
It's my personal policy not to comment on what courts might do. It's possible. I do think one of the pressure points in AI progress for the U.S. is data sources. I think the market is innovating even for those synthetic data. There's other solutions, but new data, more data, is an important balancing act to keep in mind when you're talking about limiting access to that for maybe the next companies that come along. I think that there's trade-offs that need to be weighed there.
There's a balance.
There's a balance, right? And as in most of intellectual property law, I think. But also, I'll quickly make the point that with data, it's not always more is better. We're finding that out. Up to a certain point, you need a certain amount, and it needs to be good, and there's engineering progress that can be made on top of that data. But it's not the end-all, be-all that AI, it's not the only factor that's important for innovation in AI.
Thank you.
Gentleman yields back.
Mr. Chairman, have a unanimous consent request?
Gentleman's recognized.
Mr. Chairman, I ask for unanimous consent to submit for the record the article by AI Now Institute entitled U.S.-China AI Race, AI Policies, Industrial Policy, that shows Chinese AI innovation is growing rapidly despite China having stronger antitrust enforcement than the United States.
Without objection,
Thank you.
The chair now recognizes the gentleman from Georgia for 5 minutes.
Thank you, Mr. Chairman. In an article written by Cecilia Kang of the New York Times back on last week, she reported that for just over 2 years, technology leaders at the forefront of developing artificial intelligence had made an unusual request of lawmakers. They wanted Washington to regulate them. The tech executives warned lawmakers that generative AI, which can produce text and images that mimic human creations, had the potential to disrupt national security and elections and could eventually eliminate millions of jobs. AI could go quite wrong. Sam Altman, the chief executive of OpenAI, testified in Congress in May of 2023. We want to work with the government to prevent that from happening. And so for 2 years, the tech industry, AI creators have been wanting regulation, but now we have a group of 3 lobbyists up here requesting that we not apply any regulations. What has changed, Mrs. Melugin?
Just for record-keeping purposes, I am not a lobbyist. And
well, I know that you say that you're not, but your funding,
you have to register to be a
your
lobbyist.
funding comes from the industry that you're here representing today. But let me move on. The main ingredient for artificial intelligence is data, which allows AI models to learn. Co-President Musk owns an AI company with its chatbot, Grok. And, so there's always the problem of AI companies needing to get a competitive edge, to have more data to train their models. And Co-President Musk is in a unique position now because he also runs the so-called Department of, or DOGE. In the past 2.5 months, Musk's DOGE team has gained access to vast databases at agencies like the Internal Revenue Service and the Social Security Administration, which include our personal information. And just this past weekend, DOGE gained access to the federal personnel payroll system. We know that DOGE has already copied massive amounts of our personal data onto its servers, and using that amount of data to train his AI model would give Co-President Musk a huge edge over his competitors. Now, the administration will tell us that DOGE is being careful with our personal data, but this is the same administration whose national security advisor accidentally invited a journalist to a group chat on a private, unsecured messaging app where the Trump team was discussing war plans and classified information. And it's the same administration that conducted national security business over personal Gmail accounts. This administration has a culture of playing fast and loose with secret and private information. So now, how can we trust Elon Musk with our personal data when he and his AI company have so much to gain from it financially, Mr. Bedoya?
Give a broader answer, if I may. I do think, speaking just as for the FTC, I am very worried about the information the commission holds getting in the wrong hands. The FTC regularly, as a matter of regular course of business, collects market-sensitive information about competitive strategy, and even top-level information about certain shops being active at certain times could, for a person, but definitely for an AI, be used to generate extremely sensitive inferences about otherwise confidential market activity.
So Elon Musk has his hands around that kind of information. Commissioner, I talked about the dangers of co-president using his personal data, co-president Musk using our personal data to train his AI models. Do you also see a threat to consumers? And what would your concerns be about that?
The main thing I think about with the use of data obtained from government agencies being used to train a model, speaking generally, is let's say a mistake is made and data is swallowed up into that model that shouldn't be. 20 years ago, you go into a system and just delete those files. But that's not how these models work now. This is like me saying to you, Congressman, please unlearn my face, right? Good luck with that. It doesn't make any sense. And so I'm obviously oversimplifying a little bit, but it's very difficult to unscramble those eggs. And so I'm worried about competitive information getting into these models and therefore getting into the wrong hands, even if we realize it after the fact. That is definitely a real concern I have.
And those wrong hands are not necessarily in China. They're right here in Doge.
Gentlemen's time has
Mr. Chairman.
expired.
Mr. Chairman.
Mr. Chairman, I have a UC request.
Gentleman's recognized.
Thank you, Mr. Chairman. I request unanimous consent to submit a CNBC article entitled Elon Musk, who co-founded firm behind ChatGPT, warns AI's one of the biggest risks to civilization, where Elon Musk states, quote, "We need to regulate AI safety. It is, I think, actually a bigger risk to society than cars or planes or medicine," close quote.
Mr. Chairman.
Without objection, and Chairman of the full committee, Mr. Jordan, is now recognized for 5 minutes.
Let me first do unanimous consent in light of the previous question.
Chairman's recognized.
I'd like to ask unanimous consent, enter into the record story from the Hill. The FTC must be held accountable for its widespread leaks of confidential data.
Without objection.
Mr. Chilson, you worked at the FTC, is that right?
That's right.
Chief Technologist at the FTC, I think was your title?
Acting Chief Technologist, yes.
Yeah, and you focused on, I'm looking from the bio here, the economics of privacy, blockchain-related issues. Is that accurate?
That's correct.
Work for the commissioner.
Yes,
Yeah, and you're an attorney as well?
I am, yes.
You understand the Bill of Rights, the Constitution, all the things they teach us in law school and all that, all those important. Is it appropriate for the FTC to ask an American company, the journalists, that they have communicated with?
I don't think so, sir.
I don't think so either, but that's exactly what happened at the FTC Mr. Bedoya works at just a couple years ago. They sent a letter to Twitter after Mr. Musk had purchased the business and said it's recently reported that Twitter has been providing certain third-party journalists information. And they named the journalists: Barry Weiss, Matt Taibbi, Michael Schellenberger, Abigail Schreier. They name the journalists, and they say this: identify all journalists and other members of the media to whom you've granted any type of access to the companies of communication. Is that appropriate?
I don't see what it would have to do with most of the types of actions that the FTC would bring.
Seems to me it's totally getting at, violating the First Amendment, freedom of the press. You got a right as a company, people in a company, to talk to journalists. And yet the FTC wants to know any and every journalist you've communicated, name 4 specifically, and wants to know any others you've talked to. What do you think, Mr. Chilson? Pretty bad stuff that was going on there?
Yeah.
Let me ask you this then, too. They also they wanted to know every reason why Twitter terminated former Twitter employee Jim Baker. Do you know anything about that, Mr. Chilson? Why they'd be asking about that guy?
I don't know much about that, and I don't know why they would.
I got my hunches. Jim Baker was the general counsel at the FBI when the FBI was doing all the crazy things, going to the FISA court, getting warrants, spying on presidential campaigns. He then goes to work at Twitter. Mr. Musk buys Twitter and says, I'm going to get rid of this guy. And now the FTC wants to know why? I find that strange, too. Every journalist you've talked to and why you got rid of Jim Baker. Let me ask you another one. Ernst & Young was named the assessor in the consent decree focus between the FTC and Twitter. The specific assessor was a guy, David Roque. He testified under oath and said, quote, that it if Ernst & Young did not include negative findings against Twitter, the FTC raised the specter that it would create other challenges for Ernst & Young over time. Does that seem to be the kind of communication that should be going from the FTC to the assessor at Ernst & Young, Mr. Chilson?
It seems like a form of soft coercion.
Yeah, is that accurate, Mr. Bedoya? Did you guys do that? Mr. Roque, again, this is under oath in the case. Is that what happened at the FTC? Why would you tell Ernst & Young, you better find out the right thing, you better find something negative against Twitter, you may not get business with us over time?
Thank you, Mr. Chairman, for the question. I'm not familiar with that particular communication, and so given that I am under oath, I don't want to give a wrong answer here.
So are you disputing whether it happened or not? It's a court filing.
No, sir, I'm not disputing that. I'm just saying I'm not familiar with that particular communication. And like you said, I'm under oath.
I'm asking you if it's appropriate or not. It happened. Here's what he said. If Ernst & Young did not include negative findings against Twitter, the FTC raised the specter that it would create other challenges for Ernst & Young over time. You hire Ernst & Young to be assessors in these kind of consent decree arrangements all the time. You can see the obvious threat there. I'm just asking if that's appropriate.
Mr. Chairman, who is saying that statement? Who's writing it?
Documents that David Roque communicated in the court that we have that point this out.
Forgive me, Mr. Rell is an Ernst & Young executive?
Yeah, he's the assessor you guys hired.
And he was, I'm sorry, I take this very seriously, and so what I would ask is if you submit it for the record, I'll take a good look at it and give you a full and complete answer, but I'm not familiar with the context of the statement.
Why'd you have to know about Jim Baker? Why he was terminated? Companies are allowed to fire people.
Mr. Chairman, I did not sign those CIDs. I did not sign those subpoenas, and so I don't know the exact circumstances surrounding that individual.
Okay. No comment there. All right, Mr. Coniglio, Mr. Bedoya raised three concerns earlier, and I just got a few seconds, but I wonder if, and any of you three can comment on this. Three warnings that he pointed out: vertical integration, AI keeping private data private, and then the surveillance concern. Do you have a different perspective on those three concerns, or tell me what your thoughts on the three warnings he laid out in his testimony?
Thank you for the question. I can start with the first one about AI partnerships and vertical integration and anti-competitive conduct. I think that the concerns about foreclosure, which are the typical anti-competitive harm that you think about when you go with vertical integration, are certainly very premature at this stage. We see robust competition at the foundation model level and the cloud level, which suggests that a vertical integration between, let's say, a cloud company and a foundation model is unlikely to result in any sort of exclusionary conduct. With respect to the partnerships and sort of a horizontal, so to speak, reduction of competition between, let's say, a big tech firm that may have a partnership, and the idea being that because they're investing in these companies, they're less likely to compete. Again, I think it's unlikely that that's going to result in a substantial lessening of competition, again, because of the robust competition that exists at the foundation model level, but also because of the pro-competitive benefits that these partnerships can have, specifically providing AI foundation model startups with the sort of patient capital they need to grow sustainably and actually innovate faster.
Okay, good. I know I'm out of time, but can you talk about the privacy issue real quick too? Any one of you want to talk on the privacy? I mean, I have concerns about this whole facial recognition and stuff and some of the examples that Mr. Bedoya gave in his testimony. So give me your quick thoughts on that, and then I'll be happy to yield back to Mr. Chairman.
So in many ways, the privacy issue in artificial intelligence, especially these deep learning models, is much more complicated than it is in the form of social media. And so when you train these models, what you get is something that does not have any of the actual training data in it. So you can never look into a model and see the specific training that was in there. So the privacy implications here are ones more on the inference side and not about actual data being in these. Okay. And so it's much more like remembering that something happened, but not remembering it precisely, and therefore I think I think the privacy concerns are less.
Gentleman's time has expired.
Thank you, Mr. Chairman.
Gentleman yields back. I ask unanimous consent to enter the record the letter from Gary Shapiro and Kinsey Fabrizzo of CTA dated April 2nd, 2025. Also the statement of Jennifer Huddleston from Cato dated April 2nd, 2025, and the letter from Graham Dufault of the App Association dated April 2nd, 2025. Without objection.
And Mr. Chairman?
This gentleman from Illinois has a UC request.
Yes, thank you, Chairman. I request unanimous consent to add to the record a Tech Policy Press article entitled "Doge Plan to Push AI Across the U.S. Federal Government is Wildly Dangerous."
Without objection.
Thank you.
The ranking member of the full committee is now recognized for 5 minutes.
Thank you kindly, Mr. Chairman, and thanks to our witnesses today. It's hard to think of an antitrust matter more pressing than concentration in the AI market. The dominance of a handful of AI companies presents a long-term problem for our national security, our democracy, our privacy, and basic fairness in the marketplace. But President Trump has plunged our government into chaos and disabled the federal agencies that we depend on to address such problems. It will be difficult to effectively respond to dangerous market concentration in the assembly of all human knowledge if we have governmental power that is dangerously concentrated itself in the president to the exclusion of Congress as the lawmaking branch and the judiciary as the protector of constitutional rights and values. Over a century ago, Congress established the Federal Trade Commission. It was created as an independent agency to enforce antitrust and consumer protection laws outside of the controlling pressure and power agendas of any single president or party. For more than a century, the FTC has protected Americans against scams, fraud, and other unfair and deceptive practices. It's also promoted and protected competition in the marketplace, which benefits consumers, workers, and small businesses, driving innovation in business without monopoly. Congress designed the FTC to be led by 5 commissioners across party lines who serve 7-year terms, are subject to Senate confirmation, and can only be fired for cause. Congress structured this independence to ensure that the FTC would serve the nonpartisan interests of the American people and be insulated from partisan political control. Over 90 years ago, the independence of these commissioners was tested, and the Supreme Court unanimously reaffirmed that the president cannot unilaterally fire an independent FTC commissioner without cause. Unitary executive power violated the careful federal design and infringed Congress's lawmaking power to establish the FTC as an effective and balanced instrument for the public good. Yet President Trump chose to violate federal law and defy the court's longstanding precedent by attempting to fire without cause the 2 Democratic members of the FTC. He did so to end the nonpartisan independence of the FTC and to make sure it responds to his momentary political demands above the national public interest as contemplated by Congress. Accordingly, the commissioners have brought suit to reverse their unlawful firing and to, as Commissioner Slaughter stated, make sure that the work of the commission is done without fear or favor, and more specifically, that we can take on the biggest companies in America without fear of getting fired for failure to do a favor to the president's friends or donors or corporate allies. The strongest federal rules on AI were established by President Biden in a 2023 EO. The Trump administration reversed that executive order, which laid down the guardrails for the AI industry. Not content with this rollback, the president has now hobbled and undermined the lead cop on the AI beat, the FTC, which has for years been at the forefront of holding big tech, including AI, to account. It's hard to debate the proper scope of regulation in this political space when Donald Trump has reportedly granted Elon Musk unlimited access to our most private and sensitive records, data that's undoubtedly invaluable to XAI, his AI company. Today, none of us here know whether Musk is using our data, classified information, and other sensitive data from databases across government to train his company's AI models and gain an unfair advantage over competitors and against citizens. Musk has refused to answer our many requests on this topic, and now he's crippled the agency charged with investigating these very tech abuses. Even if we came together and found agreement on regulatory reforms and safeguards for AI development, we still now lack an expert independent agency to enforce our decisions. The president and Musk are ushering in a new regime in which monarchical power, cronyism, corruption, and sycophancy rule. He's using his office to enrich himself, his friends, and his donors, all at the expense of the people. The attempted firing of 2 FTC commissioners and his subsequent removal of any FTC resource that might serve as a check on big tech illustrate how the president is dismantling the machinery of government to serve his own ends. Our constitutional order is under attack to concentrate all political power in the president. It's the political equivalent of what we're trying to prevent in the economic sphere. I hope that our witnesses can give us their best insight as to how to deal with this problem, but we're facing a structural crisis now in our government. Thank you, Mr. Chairman. I yield back.
Gentleman yields back.
Mr. Chairman.
The chairman is recognized for a UC request.
Yeah, I'd ask unanimous consent to enter into the record the letter from August 26th of last year sent by one of those oligarchs that the ranking member just put up there, Mr. Zuckerberg, the letter he sent to the committee saying that they in fact censored Americans at the request of the Biden administration. I yield back.
Hearing. We thank the witnesses for appearing before the committee today. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. Without objection, this hearing is adjourned.